Hello, my name's David Winch. I'm a chartered accountant with Bartfields Forensic Accountants. And this is the fourth and last part of our webinars series on the Law Commission consultation on confiscation. So let's see if we can get started. The agenda today, I'm going to start by talking about reconsideration. Firstly, briefly, reconsideration of benefit under sections 19 to 21, then reconsideration of available amount under sections 22 and 23, and obviously these are the ones that cause us the most difficulty and the most interest. And then a quick mention of discharge of confiscation orders, which is a form of reconsideration under sections 24 to 25A. Then we're going to move on to consider fairly briefly confiscation and compensation, and then look at multiple orders. And here I'm talking about the situation where the same defendant, I was going to say individual, of course it could be a company, but the same defendant has been over a period of time subject to confiscation orders more than once. So I'm not here talking about the situation where you've got several co-defendants subject to confiscation in respect of, say, conspiracy or something like that. And then I will finish with a very brief overview. Okay, let's get cracking then. Reconsideration of benefit. As I mentioned, it's sections 19 to 21 of the Proceeds of Crime Act 2002. And what these sections do essentially is that they employ the machinery of the making of an order under section 6 and the various sections that go with that through to 18A. So effectively, it is the making or remaking of a confiscation order. For example, where a court has decided for some reason that the defendant has no benefit at all, and there's an application made to look again at that and to make a confiscation order. These particular sections haven't given rise to many problems, and they are not focused on in the Law Commission consultation paper. And yeah, I think that's fair enough. They're not giving rise to difficulties. But now, reconsideration of available amount. Here we're looking at sections 22 and 23 of POCA. And I have deliberately included 22 and 23, although I recognise that the problems arise particularly in relation to 22. Now, these sections do not employ the machinery of sections 6 to 18A. They work on a different principle from the reconsideration of benefit sections that I mentioned a minute ago. The only section, in fact, that they rely on in terms of the reconsideration is a modified version of section 9. Section 9, of course, is the definition of available amount. And what these sections do is they vary an existing confiscation order. They do not make a confiscation order. They do not remake a confiscation order that's been made incorrectly. They vary an existing confiscation order. And I would suggest that is an important element of what sections 22 and 23 do. And indeed, sections 22 and 23 are really very similar in lots of ways. These are the most frequent types of reconsideration that we come across in practice. Section 23 probably the most frequent of all, but section 22 is increasingly popular with prosecutors. And sections 22 and 23 actually require the court to consider what is just. Now, I know some of you might be thinking, well, no, section 23 doesn't require the court to consider what is just. It's pretty much automatic. You just adjust the available amount to what it really is. But actually, if you look at the detail of the statute, section 23 does indeed require the court to consider what is just, even though that might not be a difficult question for the court to resolve. Of course, in the case of Section 22, it is a much more difficult question to resolve. So let's look briefly at Section 23. Section 23 can only result in a reduction in the amount ordered to be paid, or no change if the application is unsuccessful. So Section 23, we're looking for a reduction in the amount ordered to be paid. And it requires consideration of the disbursement of the available amount that was found at the time the order was made. This is really based not on statute, but on case law. The logic of it is this, that if the court has made an order and made a finding that the defendant has an available amount of £50,000, let's say, and he then turns around a few weeks later, goes back to court under Section 23 and says, I haven't, my available amount is much less, then the court, having made that finding of fact previously, that has got to be explained. What has happened to his available amount that was found by the court earlier, so that his current available amount requires an adjustment to the amount ordered to be paid. To do otherwise would simply allow him, wouldn't it, to relitigate the finding that had been made earlier as to what his available amount was. If he just turned up and said, no, my available amount is only £10,000, well, he's relitigating something, or attempting to relitigate something which the court has already reached a conclusion about. So as a matter of case law, the defendant who makes an application, and it usually is the defendant who makes an application under Section 23, is going to have to explain to the court what has happened since the finding was made of his available amount, what has happened to those assets identified at that time. Of course, he's got a problem with that if those assets were not specified, if there was a hidden assets finding, an unspecified unknown assets amount that was included in it, because how can you explain what's happening to something that wasn't, what has happened to something that wasn't identified as existing in the first place? But that's somewhat of an aside. Section 23 then, case law says it requires a consideration of the disbursement of the available amount found at the time the order was made. And what Section 23 does, if you look at the statute, is require the court to compare the defendant's current available amount, his available amount today, with the amount remaining to be paid. So if, let's say, a few weeks ago it found that he had an available amount of £50,000, which was £40,000 in the bank account and a car worth £10,000, let's say, and he comes back under Section 23 and says, I've paid the £40,000 out of the bank account, I've only got the car left and it's not worth £10,000. I'm going to be able to sell it, I'm only going to get £5,000 for it. So he's making an application under Section 23. Well, what the court is actually then going to do is look at his available amount today, and his available amount today is the car. He hasn't got the money anymore because that's been used towards paying the confiscation order. So his available amount today is the car. Let's say the court accepts that the value of the car is £5,000 and the amount remaining to be paid is £10,000. Was 50, he's paid 40, it's £10,000. So the court will compare that £5,000 available amount today with the amount remaining to be paid, and it will adjust the amount to be paid under the order if it considers it is just to reduce it. So in this case, if it accepts what the defendant is saying, it's going to amend the order so that the amount to be paid under the order becomes £45,000, where it was £50,000. The amount to be paid becomes £45,000, of which £40,000 has been paid, and therefore the amount remaining to be paid is £5,000. He's going to satisfy that by selling the car. And that's how Section 23 works. It's not generally problematic. Very often these things can be agreed between defendant and prosecution, and it'll go through as an amendment without any problem. There's no time limit on this. A Section 23 amendment can be made at any time, so long as the order has not already been paid off in full. And of course, if the order has already been paid off in full, then there's no need to make an application under Section 23. So effectively, there's no time limit on a Section 23 application. Now, why am I making a meal out of Section 23? Because Section 22 is very similar. And that sometimes is not appreciated fully. So Section 22. Section 22 is a mirror image in the sense that it can only result in an increase in the amount ordered to be paid, or if the application is dismissed, there's no change. So if there's a variation, it's going to be an increase in the amount ordered to be paid. Note, incidentally, I'm talking about the amount ordered to be paid. I'm not talking about the available amount. There's a difference. Section 22 does not require consideration of disbursement of the available amount found at the time the order was made. Why is that? Well, I don't know, but it doesn't. So what Section 22 does then is compare the current available amount with the available amount found when the order was made, or if the available amount has previously been varied under Section 22, with that figure, the varied available amount. And if the current available amount is greater than the available amount when the order was made, and only if, and taking into account inflation, then the court can go on to vary the original confiscation order in line with what is just. But it is, Section 22 often is problematic because there are issues as to what actually would be just, and so on and so forth. And frankly, Section 22 is not, it seems to me, is not well understood and well applied by prosecutors. But I'm digressing there from the Law Commission findings. So let's concentrate on what the Law Commission is saying. The Law Commission focuses on three issues in relation to Section 22. The first, should there be a long stop time limit? I said there's no time limit on Section 23, there's no time limit on Section 22. Is it right that the court should be able to consider 1 year later, 5 years later, 10 years later, 20 years later, 30 years later, whether the defendant now has an available amount that makes it appropriate for and just for a variation in the amount ordered to be paid under the original confiscation order? Should there be some sort of rehabilitation, long stop time limit, so that the defendant who's turned over a new leaf, who's got a legitimate lifestyle, legitimate business, making legitimate profits, should be able to say, I'm done with that confiscation order that was made years ago? Well, short answer is that the Law Commission did not feel that there should be a long stop time limit because either it would be so short as to be an invitation to hide assets, or it would be so long as to be effectively pointless. The next question they ask themselves, should there be statutory guidance to assist courts to consider what is just in these situations? There's certainly case law. Should there be statutory guidance? And the Law Commission generally felt that some statutory guidance would be helpful to courts. And should payment by instalments be an option following a Section 22 reconsideration? And they feel that that's an avenue that should be explored. I'm bound to say, well, payment by instalments is not an option in relation to the original order. Why should it be different on a Section 22 reconsideration? But that's an issue for debate and consultation. What does the consultation paper not ask about Section 22? Well, it doesn't ask if Section 22 is fit for purpose. it doesn't say that, as I would feel, that Section 22 appears to deal adequately with the defendant who conceals assets held at the time the confiscation order is made, but perhaps does not deal correctly with assets acquired post-confiscation, after acquired assets. But these are matters on which they certainly would be welcome to hearing responses from the likes of you. Right, let's quickly mention discharge of orders. Sections 24 to 25A of POCA. Essentially, these are about tidying up small outstanding amounts which are not sensibly collectible. So, for example, where there's a small amount outstanding and the defendant has actually died and there's no money in the estate, it doesn't make a lot of sense to keep these old confiscation orders on the books. It doesn't make a lot of sense to keep a confiscation on the books where there's, what, 20 or 30 pounds to pay or something. And these sections give you a regime by which you can discharge the orders. And they've not given rise to problems. Right, let's move on. Compensation and confiscation. Compensation, of course, is not the focus of the consultation. The consultation is about confiscation, and compensation really is outside of their scope. So they don't spend a lot of time on it. They point out that confiscation and compensation do not really work particularly well together from the point of view of the person who is due compensation. We've got Section 13, haven't we, which deals with the situation where the defendant is not able to pay both the compensation order and the confiscation order. And it says, in effect, that the compensation order gets priority. Okay, but what if the defendant is able to pay both? It just doesn't deal with it very well. And the Law Commission point out that confiscation law can rather get in the way of prompt and adequate compensation, partly because the court can't make a compensation order until the confiscation is sorted. And the confiscation might take a year or two, even longer, to sort out. In that time, the compensation order can't be made, the victim can't be compensated. Is that sensible? The Law Commission obviously feel that it isn't sensible for compensation to have to wait until after confiscation has been sorted. And they make various proposals which will hopefully assist with that. Right, time is moving on, so we will crack on into multiple confiscation orders. These are not a terribly frequent occurrence. We may see them more and more, of course, as we see more and more confiscation orders being made. Sections 8, which deal with benefit, 9, which deals with available amount, and 10, which deals with the criminal lifestyle assumptions, all have provisions which are relevant to the situation where the same defendant is subject to confiscation more than once. The impact of those on multiple confiscation orders appears to be not well recognised and not well understood. And I'm going to go through it quickly. Where all the orders are particular benefit only, then there's no problem. Each order addresses the particular benefit of the defendant's particular criminal conduct, and away you go, no problem at all. But where a criminal lifestyle order is present, then what's required is what the Law Commission referred to as a running total approach. And if you're not familiar with that, then the first place to look is subsection 5 of section 8, which is the kernel of the running total approach. But the criminal lifestyle assumptions cannot apply to overlapping periods. So if Fred is subject to a criminal lifestyle confiscation order in 2017, and he's subject to another criminal lifestyle confiscation order in 2020, then if you go back 6 years prior to the date of the charge in relation to the 2020 order, you will overlap a period, won't you, which has been covered by the earlier confiscation order, and that's not appropriate. So those overlapping periods are not permitted, and that's dealt with in subsection 9 of section 10. Any amount which has previously been ordered to be paid on an earlier confiscation order and is still unpaid is a debt having priority in terms of calculating the defendant's available amount. So if you look at subsection 2A of section 9, the available amount, debts having priority, a previous unpaid confiscation order has an impact there. So it will have an impact on the defendant's current available amount. Let's take an example. Dan, hypothetical Dan, is subject to a confiscation order in 2012. His benefit is £200,000. His available amount is £50,000. And the amount to pay, therefore, is £50,000. No problem with that. I've not actually said whether this is a criminal lifestyle confiscation order or not. That's because I don't think that matters, but the Law Commission do. And the explanatory notes to POCA do. So I'm in a minority of one here. So if it helps you, let's say that this was a criminal lifestyle confiscation order in 2012. Right, benefit £200,000, available amount £50,000, amount to pay £50,000. No problem there, all straightforward. Dan has only paid £30,000. And simply to make the figures easy, we're just going to ignore interest. So there is £20,000 remaining to pay still under that confiscation order made in 2012. Now, Dan's convicted of a new offence, a new criminal lifestyle offence in 2019. And he's going to be subject to confiscation. And we have a look at the section 16 statement. Dan's benefit is £1 million in relation to this new offence. That can be actual plus assumed benefit. Dan has assets currently, today, of £100,000, and he's made no tainted gifts. Again, the reason he's made no tainted gifts in this example is it just makes matters easier if he hasn't. So, right, so what's going to be the confiscation order that's going to be made today against Dan, assuming all these figures are agreed or are the basis of a finding in court? Well, Dan's new confiscation order is going to show a benefit of £1,150,000. Why is that? Because there's £1 million of benefit that we've found under the new section 16 statement. Added to that, the £200,000 of benefit that was found by the court in 2012 makes £1,200,000. But we've got to deduct from that the amount he was ordered to pay in 2012, which was £50,000. So 1 million plus 200,000 minus 50,000 gives you a benefit figure for the new confiscation order of £1,150,000. And his available amount is £80,000. Why is his available amount £80,000 when I said he had assets of £100,000? Because he's got a prior liability of £20,000 under the old confiscation order, and that's deducted under subsection 2A of section 9. So the order is going to be that Dan pays, the amount to be paid for this order is going to be £80,000. Now, who knows what's going to happen here? Is Dan going to pay up that £80,000 but still not bother to get round to paying up the remaining £20,000 that's due in relation to the order from 2012? It's all a bit of a mishmash and a mess, isn't it? The court's going to have to pursue him for that £20,000 outstanding on the 2012 order, plus the amount that he's ordered to pay today. But the court's going to have to remember not to make a section 22 application on the old order, because that benefit of £150,000 that he wasn't ordered to pay in 2012 is included in the new order. So it wouldn't be just, would it, to have a section 22 application based on the 2012 order. So all a bit difficult and complicated. What the Law Commission proposed is that courts should have powers to consolidate multiple confiscation orders in this sort of situation into one new order, and to amend earlier orders appropriately in consequence. That would also allow, they say, priority to be given to any compensation elements. Suppose Dan had been ordered to pay compensation in relation to the first order in 2012, but not in relation to the second. Well, if he pays up some money, should the compensation be paid or not? One of the other points that they've made about compensation, which perhaps I should have mentioned, is that you can, of course, go back and vary a confiscation order under Section 22, but you can't go back and vary a compensation order. Is that right? Is that fair? Is that appropriate? Again, a topic, if you like, for discussion. Right, this is my final session on the Law Commission consultation. I have, of course, gone through things fairly quickly. I have been necessarily selective. I have taken some personal points of view on various things. What I have said previously, and I'm going to say it again, is that there is undoubtedly a tremendous amount of valuable material in the consultation paper. And this is, frankly, a once-in-a-generation opportunity for practitioners to have some influence on improving the nuts and bolts of the statute law, the criminal procedure rules, and the practical operation of confiscation. As part of my preparation for these webinars, I reread some of the House of Commons Standing Committee discussion of the Proceeds of Crime Bill in 2001, which became, of course, the Proceeds of Crime Act of 2002. And suffice to say, you've seen parliamentary questions to the Prime Minister. You know how things work in the House of Commons. Even in standing committee, which is supposed to be the detailed technical examination of the nuts and bolts of the statute, there is a lot of party politics. There is a lot of discussion as to whether members should be wearing jackets or not when they're in the committee, whether they should be standing up or sitting down when they speak, and all this sort of stuff. What there is not is the sort of detailed examination that the Law Commission have done of the working of the statute, of how the detailed provisions operate, or the detailed knowledge that you have as practitioners of this in the courts, day in and day out, how it actually works on the ground. You have a lot to offer, I believe, to the Law Commission, to this review of confiscation, and it is a once-in-a-generation opportunity. It's not going to happen again. This law has been on the statute book since 2002, admittedly amended and amended and amended, but it's been there since 2002. This is a first and perhaps only opportunity to look at how it works in practice from the experience of practitioners. Even the Law Commission are limited, of course, in the day-to-day experience of how this works in the Crown Court. And this is our opportunity to tell them what would make things work better. The closing date for the consultation is the 18th of December. I do encourage you to go on the Law Commission website, use the software they've got on there to enable you to more easily respond to the questions. You don't have to respond to all the more than 100 questions that are posed in the document. You can pick and choose, say your bit, and have done. And please do so for the benefit of all of us. Right, and finally, Bartfields. Bartfields forensic accountants. In this second lockdown, we remain fully staffed. We're still undertaking legal aided and privately funded criminal and civil forensic accountancy work. As I've said before, it's relatively easy for us to conduct the bulk of our work remotely using up-to-date and secure IT facilities, and we are readily contactable by phone, email, and online. The website was updated a few months ago. It's full of useful information and, of course, is accessible 24/7. You can find more on this topic in our website area, the news area, or the seminars themselves. Recordings of the seminars and the slides from the seminars are available in our seminars section. We will send you a free recording of this webinar. And if you've got questions, please do email me. My email address is there, davidwinch@bartfieldsforensic.co.uk. Phone number's there too, but I would prefer email because then I can actually think about the answers before I reply. In a fortnight's time, I will be looking again at multiple orders and section 22 and how these fit together, because that is worth a half hour all on its own, and we only went through it quite quickly today. So thank you again for your time, and please do respond to the Law Commission consultation, and I will see you in a fortnight. Thank you very much. Goodbye.